सुप्रीम कोर्ट कॉलेजियम का बड़ा दांव, जस्टिस जयमाल्या बागची बन सकते हैं 2031 के मुख्य न्यायाधीश। नाम शायद आपने ज्यादा नहीं सुना होगा, लेकिन अब ये नाम पूरे देश में गूंज रहा है। जस्टिस जयमाल्या बागची। सुप्रीम कोर्ट कॉलेजियम ने अचानक ही उनका नाम सुप्रीम कोर्ट के जज बनने के लिए सिफारिश कर दिया है और अगर सब कुछ प्लान के मुताबिक चलता रहा तो 2031 में वो भारत के मुख्य न्यायाधीश यानी कि CJI भी बन सकते हैं। सवाल ये है कि आखिर अचानक ये नाम कैसे आया। देखिए, सुप्रीम कोर्ट कॉलेजियम हमेशा से हाई प्रोफाइल जजों के नाम की सिफारिश करता है, लेकिन इस बार मामला थोड़ा अलग है। जस्टिस जयमाल्या बागची का नाम अचानक कैसे आ गया? क्या उनकी काबिलियत इतनी दमदार है कि कॉलेजियम को सोचना भी नहीं पड़ा, या फिर बैकग्राउंड में कोई बड़ा समीकरण खेल रहा है? कौन है जस्टिस जयमाल्या बागची? अब सवाल ये उठता है कि आखिर जस्टिस जयमाल्या बागची हैं कौन? 2011 में पहली बार कलकत्ता हाई कोर्ट के जज बने। 2021 में आंध्र प्रदेश हाई कोर्ट भेजे गए, लेकिन कुछ ही महीनों के बाद वापस लौट आए। 13 साल से ज्यादा का तगड़ा अनुभव। इनकी खास बात यह है कि ये हर तरह के मामलों में बेहद साफ और दमदार फैसला सुनाने के लिए जाने जाते हैं। 2031 तक मुख्य न्यायाधीश, इतना बड़ा फैसला। अब सबसे बड़ा सवाल, 2031 तक CJI बनने की बात कहां से आई? CJI बनने के लिए सबसे जरूरी है कि कोई जज लंबे समय तक सुप्रीम कोर्ट में रहे। अगर उनका नाम सुप्रीम कोर्ट में फाइनल हो जाता है तो 2 अक्टूबर 2031 तक उनकी रिटायरमेंट नहीं होगी, यानी कि वरिष्ठता के हिसाब से जब उनका नंबर आएगा तो वो CJI बन सकते हैं। क्यों खास है ये नियुक्ति? अब इस सिफारिश के पीछे कई बड़े कारण छिपे हुए हैं। कलकत्ता हाई कोर्ट से 2013 के बाद कोई CJI नहीं बना। अब तक इस हाई कोर्ट के जजों को टॉप पोस्ट से दूर रखा गया। जस्टिस बागची की नियुक्ति से इस संतुलन को ठीक किया जा सकता है, यानी इस नियुक्ति से सिर्फ एक व्यक्ति नहीं बल्कि पूरी न्यायपालिका का संतुलन बदल सकता है। क्या सरकार इस पर ऐतराज जता सकती है? अब सवाल यह भी है कि क्या केंद्र सरकार इस फैसले को आसानी से स्वीकार कर लेगी? सरकार पहले भी कॉलेजियम के कई फैसलों पर असहमति जता चुकी है। कई बार सिफारिशें टाल दी गईं। तो क्या इस बार भी ऐसा होगा, या फिर जस्टिस बागची की नियुक्ति को हरी झंडी मिल जाएगी? आगे क्या होगा? अब सबसे बड़ा सवाल, क्या जस्टिस बागची का नाम फाइनल हो जाएगा? अगर हाँ, तो यह भारतीय न्यायपालिका के लिए बहुत बड़ा बदलाव होगा। अगर ना, तो क्या ये नियुक्ति भी विवादों में घिर जाएगी? आपकी क्या राय है? क्या आपको लगता है कि जस्टिस जयमाल्या बागची CJI बनने के सही उम्मीदवार हैं?
Lord, there is something inherently appealing in the argument of the petitioner. Justice has been done. That's the first, my lord, point that certainly strikes the judge, that some injustice has been done and we must step in and solve the problem. This is, my lord, the first. There are 3 limbs to the argument. This is the first, my lord. Prima facie looks very appealing that some injustice is being done to me. Why should not the court after?
I will not go to that extent. Let me put it very clearly. Normally, as a court, there are 2 factors which play with us. One is to do justice, remedy the wrong. That's a factor.
That's the instinct, my lord. That should and is
No,
should be the instinct.
Let's, if there is something wrong, let's
not fix the
remedy
problem.
wrong. 2 is the courts like to normally assume a power because adjudicatory functions should not be curtailed.
So, my lord,
Not be unnecessarily curtailed until unless the statute specifically, expressly, or by implication takes away that power.
So if I can summarize, my lord, the other side, there are 3 limbs to the argument. One is, if there is some injustice, court's power should not be curtailed. The court ought to, as a matter of justice, step in and fix the problem. This is proposition 1, my lord, which itself I will say something on. Proposition 2 is, if that be the case, then maybe 34 does not have the word vary or modification. However, in order to, my lord, support proposition 1, I will persuade the bench to read it in one of 3 ways. One is adding words, one possible submission. Second is read it in 34(1) as part of setting aside. Second possible interpretation. according to me, my lord, the one which we will have to deal with. And third, forget 34.1, let us read it in 151. So this is point 2, my lord. So point 1 is the court should have the power. Point 2 is if the court has the power, these are one of 3 methods to do it. And 3, realizing there's a problem with an untrammeled power, we realize there's a problem that there cannot be untrammeled variation. Guidelines have been suggested by various parties in various different ways. Possibly all of them, my lord, suiting their particular facts of the case. So everybody has their own, my lord, guideline, which perhaps will fit whatever factual background that particular individual has to place or perceived injustice. Lord, we are in a position, my lord, as the learned solicitor, my lord, we are not here on any particular set of facts. There are weighty arguments.
They are appearing for whom?
My lord, I am appearing for UNCITRAL, UNCCI, my lord. We have intervened as UNCITRAL. There are weighty arguments, my lord, which have been made on the other side, no doubt, my lord. But I will just, my lord, I think we should step back a little, because I think, my lord, we are proceeding on a bit of a misconception, which is this. My lord, we are treating this as an appeal from a judgment. In our mind, my lord, in the court's mind, that the thinking is that this is in some way an appeal from a decision by a inferior court. And, my lord, there are at least, I'll attend them, my lord. My lord, there are at least 3 or 4 aspects which your lordships will consider before coming to the next question is, when can you attack an award? So, my lord, what is critical here is that an award is a baby of a private dispute. It is supposed to be out of the system. It is not supposed to be in the system. It is supposed to be out of the system. There are some implications here. My lord, an award is meant to be final and binding. Very important. It has to be final and binding. It is a consensual process. The moment the arbitrator finishes, his mandate gets over. Consent is over. Subject to, of course, correction and remand. The mandate is over under Article 32. The arbitral tribunal becomes functus officio. So, my lord, there are 2 policy aspects to an award which are not there in a lower court judgment. One is party autonomy, and I'll explain what is the relevance, because I think this is crucial. And secondly, my lord, finality. You go into arbitration, nobody is forcing you, my lord. We have to proceed on the basis that nobody is forcing you to go to arbitration. It is a consensual process. The consequence of this, which has not been, my lord, probably appreciated by the other side, is an arbitrator can be wrong. An arbitrator can be wrong on the merits. He can be wrong on his appreciation of evidence. He can be wrong on the interpretation of law. But the law provides that because I have gone to somebody else other than the courts will never tolerate a wrong order. But I have gone to somebody else, I will take that wrong decision because I want finality. I want a binding award. Therefore, my lord, 34 is restricted, that it has to be at the level where there has to be patent illegality. So, my lord, the first point I want to make is, please do not consider this as an simply, my lord, the intention is to keep it out of the court. So, my lord, however much the instinct is to render justice, that justice has not to be rendered by the court, but that justice has to be rendered by the tribunal. Where your lordships are eager to fix the problem, the first proposition, the law provides and the statute provides that that is a remedy available to the tribunal. And opportunities are given to the tribunal in every stage. A lot award comes if there is clerical, etc., mistake. Then under the old act, section 15, which your lordship was referring to, it went to the court. But that is no longer the case. Section 33 is the tribunal. Please keep tribunal on one side, court on one side. 34.4, again an option. Surely the court could have intervened and said, I'm fixing the problem. No, The intention of the law is save the award, go back to the tribunal under 34.4. No, I'm not on the scope of 34.4. Go back to it. The third option. Why is setting aside so critical? Not because of essentially why is modification not provided? Because of the problem of cherry picking. If you actually believe, if you really believe that that tribunal has messed it up, that it has not followed natural justice, or it has gone completely outside the jurisdiction, or it has made such an obvious patent blunder, why should you trust the tribunal's judgment on other points? I give a simple example, and it happens every day. 5 claims are made. 4 are rejected. 4 may be wrongly rejected because it may have been in appeal reversed, but 4 are wrongly rejected. There is no 34. The 5th claim is allowed, but even there the arbitrator commits a mistake, maybe on the overhead or A, B, C, D. If the court tweaks, let us say 5, what is the consequences? You are cherry picking one part of the award. The person who has actually lost, in a sense, because 4 of his 5 have been wrongly disallowed, has no remedy because he accepts the wrong judgment of the arbitrator. So, my lord, when your lordships come to a conclusion of patent, it's a very serious matter to set aside number. When your lordships come to the stage of patent illegality or the stage of setting aside cannot be the norm. Then, because of the seriousness of the matter, the set aside follows, because your lordships have lost faith in the tribunal. It is not an appeal where your lordships will modify this, change this. So, my lord, this is my first.
If he has not challenged the rejection of the 4 claims.
My lord, he may have not been able to challenge the rejection of the 4 claims because even though it is wrong.
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।